Hi there, this is Jonathan Ginsberg. I'm an Atlanta area personal bankruptcy attorney, and today I'd like to talk to you about private student loans and what you can do with them in bankruptcy. And I want to make clear that I'm talking about private loans as opposed to government loans. The difference is that with the government student loans, ones that are guaranteed or issued by the federal government, you have a number of options if you run into trouble, the income-based repayment plans and so forth. Private loans are different. There's about 15% of the student loans out there. These are ones issued by Discover, Chase, a number of different companies. And typically, I see a lot of times private student loans when people have gone to expensive private colleges and they've used up all their government student loan allocation, and so now they turn to private student loans. And it's very frustrating to talk to people because a lot of times when they took the student loans out, the private loans, they didn't realize that there's not a lot of options if you run into repayment problems. And of course, it's really frustrating when you talk to somebody who's gone to school and got a liberal arts degree and now can't find a job making $20,000 or $30,000 a year, and they've got $100,000 in private student loans. It's a real problem, but that's kind of an issue for another day. So what happens if you find yourself in that situation? You've got private student loan debt and you are struggling with a possible default, you're getting collection phone calls, letters, that sort of thing. Well, in the bankruptcy world, there's not a whole heck of a lot you can do with private student loans. Obviously, the one thing you could do if you are medically disabled, you could ask for a discharge under the undue hardship provision. The bankruptcy code basically says that if not discharging the loan, the student loan would create an undue hardship, then you can discharge the student loan in full or in part. And basically, undue hardship is typically defined by bankruptcy judges around the country as being a situation where there's no possibility you'll ever be able to pay the student loan back. Usually it's medical based. So if someone has a severe medical problem, they can't work, that might be grounds for an undue hardship discharge. But absent that, the fact that you're not making enough money or that you're unemployed is not going to be enough to get a hardship discharge. Now, you can sometimes get part of the loan discharged if you can show that for whatever reason your income ceiling is here and you would need it up here to pay the student loan back. Again, difficult to prove, but judges are open to that if you can show why you would not be able to pay all of it back. But again, very difficult to do. And of course, one of the practical problems is in order to go after a discharge in bankruptcy, you've got to be able to pay a lawyer to litigate the matter in bankruptcy court. And when you talk about bankruptcy court litigation, you could be talking about $2,000, $3,000, $4,000 to litigate. Now, if you're able to get rid of $50,000 or $60,000 in student loan debt, it's worth it. But not a lot of people going into bankruptcy have $3,000 or $4,000 to throw in an attorney for discharge litigation. So in any case, that's one option. The other options are less palatable, and really they're more in the form of buying yourself some time, hoping things will improve. So here are the options I give people when they call me and say, I've got a private student loan, I'm in default or about to go in default, what can I do? Well, one option is you could go into a Chapter 13 bankruptcy, which creates an automatic stay, which again stops all collection activity. And during the term of the bankruptcy, which is going to be about 5 years in most cases, you can pay something towards those private student loans. So you won't be able to get rid of the student loan in full, but if, let's say you can allocate $200 a month to the private student loan, when you get out, yes, you'll have accrued interest and you'll have the balance remaining, but you'll be able to knock some of it off, but do so under your terms. And in theory, you could file another Chapter 13 right after that, do the same sort of thing, and just use it as a way to get an extended payment plan at some rate that you can afford. Again, not a great option because nobody wants to be in Chapter 13, for 5 years, 10 years, 15 years, or whatever. But again, that's an option to do if the creditor just simply won't play ball. The other reason to consider doing that is that there is some talk in Congress that private student loans may get less protection in the future, meaning that Congress is recognizing that private student loans are very difficult to deal with. There's no income-based repayment, so we may find that at some point in the future, 2, 3, 4 years from now, private student loans may become fully or partially dischargeable based on any number of factors, the age of the loan, other factors. So if you want to buy some time in the hope that that may happen, Chapter 13 could be a way to do that. The second part of using Chapter 13 would be to simply go into a Chapter 13 and pay nothing. towards the private student loan. Now, again, that's just going to mean the debt's going to accrue. You can deal with your other debts in the Chapter 13, but assuming that the trustee doesn't have a problem with it, you can simply delay collection of your private student loan for up to 5 years. And again, do that ongoing if you need to do it. And the other thing is that with private student loans, the statute of limitations, could run at some point. And if you have not made payments on it for a while, the creditor or the collection agency may lose interest and you may get a statute of limitations discharge. So a second option with Chapter 13 would be simply to go into a 13, not pay the student loan debt back at all, and then deal with it in 5 years, one way or the other. Either wait for it to be discharged by virtue of the statute of limitations, not discharged, but eliminated by the statute of limitations, or simply just deal with it down the road when maybe your income situation is better. Third bankruptcy option would be to go into a Chapter 7. Again, you're not going to discharge the student loan debt, but what you can do is use Chapter 7 to eliminate everything else, reduce your expenses so you have disposable income available to pay that student loan. So, for example, if you have a car that you're paying $700 a month on, you can surrender that car in the Chapter 7 and free up $700 a month. You can get rid of all your credit card debt, everything else you got, and use whatever money you have left to pay the student loan back, because again, private student loans tend to linger on and on and on. So that would be another possibility of using bankruptcy to deal with student loans. I actually had a client in that situation. It was a husband and wife. They had, between the two of them, close to $400,000 of private student loan debt, mostly private. And we went into a Chapter 7, discharged everything else, got rid of a few things, house and a couple of cars, and they came out of bankruptcy with enough disposable money where they could throw a bunch of money at the private student loan debt and get rid of it over time. And I assume that's what they're doing even now. So those are some thoughts about how to deal with private student loan debt using bankruptcy as either a tool to buy yourself some time or as a mechanism to get rid of other debt, and even, as I said, in certain very limited circumstances, as a way to discharge the private student loan debt. So hope this has been helpful. Any questions about this, please reach out to me. If you found this valuable, please give it a thumbs up on YouTube and a like on Facebook. And again, any questions or thoughts about this or future videos, please let me know. Thanks a lot.